Welcome. I'm Teresa Miguel Stearns, Associate Dean and Director of the James E. Rogers College of Law, Daniel F. Cracchiolo Law Library. It is my pleasure to welcome you to the very last Faculty Book Talk series of the year. Today, we are joined by Professors Bublick and Bambauer and College of Law graduate and practicing attorney Daniel Arellano on the occasion of the publication of their completely revised edition of their leading casebook, Dobbs on Economic and Dignitary Torts. Ellen Bublick is, aptly enough, the Dan B. Dobbs Professor here at the College of Law. In addition to this casebook, she is co-author with Paul Hayden several other books, including A Concise Restatement on Torts, written on behalf of the American Law Institute. Professor Bublick has served as an advisor on the American Law Institute's Restatement Third of Torts, and she serves as co-editor and writer of the Jotwell Torts blog. Her books have been cited by the United States Supreme Court and by courts in every federal circuit and in 49 states. In fact, one of her innovative legal theories was expressly adopted by the Washington State Supreme Court in 2005. An honors graduate of Duke University and Harvard Law School, Professor Bublick clerked for Judge Walter Cummings on the Seventh Circuit Court of Appeals and practiced law at Mayer, Brown, and Platt in Chicago before entering the academy. Jane Bambauer is Professor of Law and Co-Deputy Director of the University of Arizona's Center for Quantum Networks, established in August 2020 with a $26 million grant from the National Science Foundation. In partnership with Harvard, MIT, and Yale, Professor Bambauer serves as the privacy expert to help ensure the quantum network and derivative applications are socially responsible. Professor Bambauer's research assesses the social costs and benefits of big data and questions the wisdom of many well-intentioned privacy laws. Her articles have appeared in the Journal of Empirical Legal Studies and the Stanford, Michigan, and California Law Reviews, among many others. Professor Bambauer has contributed to numerous US Supreme Court amicus briefs, is frequently quoted in the popular press, and has been invited to speak in dozens of national and international forums on issues of privacy, technology, and related issues. Professor Bambauer holds a BS in mathematics from Yale College and a JD from Yale Law School. Daniel Arellano is founder and partner of Herrera Arellano LLP in Phoenix. His legal practice focuses on election law, campaign finance, nonprofit tax, government affairs, and complex litigation in Arizona, Washington, D.C., and nationally. He is a double wildcat, receiving both his BA and JD from the University of Arizona in 2011 and 2014, respectively. While a law student, he was editor-in-chief of the Arizona Law Review. Please join me in welcoming Professors Bublick and Bambauer and Daniel Arellano to our live audience here in the College of Law Faculty Lounge and to our virtual audience on Zoom. Thank you.
Well, thank you so much for that very too generous introduction. Very lucky to still be able to be in consultation with him. And also I want to add that Daniel was my very outstanding student in 2 classes while he was here. And so I'm so lucky to have made that relation. I guess maybe we should start out talking about some of the things that we really like about this book. And, you know, maybe I want to start with 2 things of having these great 2 new authors and talk a little bit about some of the things that you all have brought to the book. So the first thing is you've heard about Jane's background in terms of technology and privacy and so on. And I think that one of the things that I like the best about this book is the really exciting context that we have for a lot of the common law dignitary torts. So, you know, the Facebook cases, and I'll let Jane talk a little bit more about them, but I think sometimes when you're in an area, the internet issues get a little bit intimidating to approach because you're always a little bit nervous about what am I leaving out, what am I not seeing? And so I think having Jane as a guide in that area has been wonderful because one of the things I've seen is that actually they're more similar to the traditional cases than I thought they would be. And yet it gives me a great perspective in a way into the material. And maybe Jane, do you want to talk about some of the things that you've added in the privacy area?
Yeah, so wait, let me start by saying that Professor Bublick is highlighting some of the things that Daniel and I bring, but the background context is that Ellie brings everything else. so I got involved in this book partly to tie myself to the mast, to learn more about the context of protecting dignity through tort law, or through law in general, but especially through tort law, and protecting economic interests as well. And so I wanted to bring the sort of high-tech internet, governance angle to this book. That's what I had to give. But what I got out of it was learning how the courts have so far grappled with these kind of amorphous rights. But what I'm most proud of contributing, I'd say, are the chapters on privacy, and then also on how defamation has been dealt with in the internet age. The book starts with 4 very updated chapters on defamation law that explain the sort of basic elements and go through how those have evolved over time and what the current kind of trade-off between First Amendment rights and the right to redress have been worked out. But then on the internet, partly because of social media platforms, but even before social media, there was still enough content generated by a bunch of end users that some of the assumptions that went into defamation were just exploded. So, everyone to some extent is a celebrity in their own circles. And so there is some information about you that may be, unflattering or truly terribly damaging that might not make it to the, mass media, but it makes its way to the people, employers and whatnot they care about a lot. Things that used to be, mere slander are now almost always libel. They're in written form, right? And then from the privacy standpoint, we are all also, because it's so easy to track everyone, we are also all celebrities in the sense that we're being tracked all the time. And occasionally, like in one of the 2 big Facebook cases that we added, we're also occasionally being used for our, celebrity status, that is like to entice our friends and colleagues, those who are connected to us, to try to be spokespeople basically for products. And so so all of these things that the sort of common law had assumed would be special cases are now the general case, and that really makes it hard.
I mean, it's so interesting, the assumptions in defamation law that private people won't have access to media. That's so different now. And
right.
It's interesting to go back and think about with our new context, how much does the old law apply to those new contexts, but also how much do the new situations change what we should think about in terms of what's happening with print media? Should we still have distinctions between libel and slander, which is something that the Restatement Third is really grappling with right now? And I think that, having these new contexts in defamation makes such a difference, especially, some of the new contexts, looking at deplatforming, which has been very much in the news. And How about unmasking anonymous sources? I mean, courts say this isn't anything new. Anonymous pamphlets existed, but the extent of the anonymity and, you know, how easy should it be to identify is important. And also, you know, to what extent can you get third-party services that are immune from liability themselves to remove content that's defamatory? And I love that a lot of these new chapters really add all of those contexts that are so important today. I want to add one thing on the defamation side to get Daniel here. We asked Daniel sort of the impossible, and that is defamation law is so complex. You sort of want to start with a list of the elements, but the elements depend on, is it an issue of public concern or private concern? Is it you know, a private person or a public figure? Do we, you know, which state are we in? Do we just have the basic 3 common law elements, or has our state added some, you know, additional elements, fault, falsity, damage? And so we said to Daniel, like, you know, here's this chapter that has truth as a defense. And sometimes truth is still a defense, but sometimes, you know, you have to have proof of falsity. And one of my favorite parts of the casebook, Daniel, is Judge Pooler's case that you added about whether tannerite, what do you call it, explosives are a bomb or not. Is it defamatory to say that they're a bomb? Do you want to talk about that case? It's just one of my favorites, and it really bridges that truth falsity question so well in the book, I think.
Yeah, so one of the ways, you know, which, you know, not just tort law, but defamation law specifically has, I think, evolved is the framework of who has the burden of proving falsity. As Ellie said, does a plaintiff have the burden of proving it affirmatively as an element of the case, or is it really the defendant? And historically, it's been stated as a defense, but I think has evolved into one where, as a practical matter, really, if a plaintiff has any hope in prevailing on a defamation claim, they really kind of at the outset really have to at least sufficiently allege falsity in order to get their day in court. So one of the goals, I think, with this book, you know, with this update, you know, I took Ellie's course for this course specifically, in addition to her what she calls the baby torts course, not terribly long ago, and so I wasn't, you know, terribly far removed from it, and you know, really kind of wanted to look at this from the perspective of both having been a recent student and also a practitioner. You know, really present cases in a way that were, you know, fun and digestible, and really convey the doctrine while also being, you know, where we can find them, you know, pretty entertaining. So this was one. This was a tannerite case out of the Second Circuit, a case dealing with a news report that stated that a particular company's product, so essentially a type of gunpowder, was explosive, and the company claimed it was defamatory to have referred to this product as explosive when it really was not meant to explode. The allegation being, you know, this conveyed the point that, or that you know, these things would explode spontaneously on shelves, and really it was meant to be used with particular products. And so the case really goes into what does it mean to say that something, you know, explodes or is a bomb, and really kind of putting the onus on the plaintiff as a matter of pleading. You know, there's always kind of this, I think, this interesting interaction between torts and civil procedure in terms of how you allege a case, how you prove a case, who bears the burden, and really working through on a, you know, Rule 12 basis what the plaintiff has to prove or allege with sufficient clarity to get past the pleading standard in federal court.
Let me add one other thing that you touched on, and that is I love the sort of practical perspective that you're bringing, because you've litigated First Amendment issues in defamation type cases, also in election law and so on. Do you want to talk a little bit about I don't know, some of the practice experience that you're bringing to the book?
Yeah, so I've always said, this course, what is, in some law schools called the Advanced Torts course, or we call Economic and Dignitary Torts, is really perhaps in addition to civil procedure, one of the most useful courses I think a student can take if they plan to work in civil and commercial litigation. I think this book really touches on all the topics that are the bread and butter of any commercial litigation practice, especially at a large firm. So, before we formed our own firm a few months ago to focus exclusively on election law, I did, commercial litigation at large firms for 5 years. And this was the kind of things we would litigate all the time, including defamation. And it's an area of law that I think touches a lot of areas of practice. Even now in our political law practice, much of our review, actually, for example, political ads will be for potential defamation liability or responding to threats of defamation liability. So, this course, whether you talk about that, whether you talk about misrepresentation, intentional interference with contract, we touch also on statutory consumer fraud causes of action. Those are all things that are really form the bread and butter of an active, complex litigation practice.
I want to add 2 things to what you said. First of all, in terms of the bread and butter, this was actually what I did in practice before I started. And this is sort of how this book began, is I came to law school saying, all these things that I actually practice, I never learned anywhere in law school. Like, why isn't there a class like this? Why isn't there a book like this? And I talked to my colleague, Dan Dobbs, like, I really want to write a book on this. And he said, you can't write a case book until you have tenure. That's something you have to wait to do. But when you get tenure, then I'll write this book with you. And by the way, here's a draft that I have already of, some things that I've been writing. And of course, like, Dan's incredible, and he already had, actually he probably had 1,500 pages, and I had to keep, we had to keep deciding to sort of get rid of some things too, so that we could really present this material. But I think that usefulness, when students contact me after classes and say, I'm doing this thing you taught me, I would say it's most often because of the economic and dignitary torts. And then the second thing I want to say is, as you're talking about, Daniel, the political ads, there's a case called Rogers that was just decided by the Arizona Supreme Court about political ads. And it was a 4-3 decision. It's sort of, what about defamation of a non-politician in an ad that's taking aim at a politician? And the authors of the main opinion, Justice Bublick, and the dissenting opinion, Vice Chief Justice Timmer, came and talked with University of Arizona students about that case. And one of the things that was amazing is I think that from all of the concepts we talked about in the book, there was nothing that was new, that was, it was just something that they were all really well prepared for because of these kind of materials in part that you've, really developed. So I thought that was great.
Yeah, let me add something about defamation too. Maybe it'll be a little bit of off-roading from what we've done in our book. We have included in our book some of the politically oriented defamation cases, like the suit that Dominion has brought against, several commentators. I think Giuliani and the My Pillow guy and stuff. And then Devin Nunes. But then also we highlight some examples of the Me Too or She Lied cases. And I think, I'm curious whether you and Daniel agree, I think there's an appetite to use defamation to have a court establish shared facts, in part going back to the internet, in part because we are all a bit unsettled by these filter bubbles that we're in, that we can't establish what actually happened. And so in some ways, I think defamation is becoming even a more attractive claim, not only for the redress, but just for the act of fact finding. Right?
No, that's a great point. And I think of that in respect to, is it like the Alex Jones InfoWars,
Oh, yeah.
Sandy
Sandy Hook,
kind
that's
of
it.
context, which is in some of the notes too, where, you know, you want to establish what the truth is. And yeah, it's funny. I wonder if there are other periods in history where that has seemed
Like a
important.
benefit of the, of the process of an otherwise very, time consuming and expensive process.
I mean, to some extent, that must always have been at the heart of some of defamation law, because when you're bringing defamation litigation, you're making the issue more public. And so there's always, a conversation you have to have about, do you have a case and do you want to bring a case, which are two different things. And so, that desire to show that that defamatory thing was false, the Cardi B suit against, is it Tasha K? I mean, part of that's got to be just, that is false, that the things that were said were false. So,
I'll just add that I think that's paired also with what, might be some of the kind of eroding doctrinal points around some of the First Amendment protections for certain kinds of speech. I mean, there are, at least a few members of the Supreme Court who have expressed significant skepticism about Sullivan and other protections we afford the press, which I do think it's hard as a practical matter to divorce those from the political discussion that happens around press protections and the role of the press in American politics. And so this is I think one of the challenges with this book was, I mean, even as you're writing and revising, it almost feels like it's out of date because things evolve just so quickly. And I imagine, even within the next year or two, we'll have, substantially more to add to the next edition.
Yeah, that makes a lot of sense. And I want to add one other context that we've added in the defamation cases. We added some race defamation cases, in addition to some of the questions of some of the gay defamation cases, and really talking about the importance of social context to defamation and the way in which social context is, what is defamatory depends so much on what is the social context of a time and changes so much. And so I think your point about things constantly changing, the way we think, for example, about saying that someone is gay when they're not, just in the 20 years I've been teaching, has changed very much in terms of what courts will say in their opinions, and appropriately should change. And I think that's one interesting social artifact of defamation law, is watching the culture change as you watch the law change.
So you were the primary author, and I mean, basically, effectively, the only author for the economic torts. So let's go through some of the big changes between the last version and this version for those torts. Well, first of all, is there anything you want to highlight first, and then I have a couple.
Yeah. Well, I mean, of course, everyone is too generous to me, and I never mind it. But I will say the biggest changes that we've made in the economic torts chapter, first of all, we have a whole chapter on the economic loss rule. And I think that's really important because you see studies where, in the 1960s, 1970s, nobody talked about economic loss rule. It didn't really exist. And then it sort of existed, and then it existed more. And now, there's a lot of debate in a lot of jurisdictions about the economic loss rule. And so we added a whole chapter really highlighting these important cases and sort of showing the different context, the products liability context, which is where the doctrine came about, and then the contracting context, which is what the restatement third defines the whole economic loss rule to be about. And then this sort of stranger context where a number of courts are saying, should we expand the doctrine into that area? So, so I think that's one of the biggest changes.
Okay, and so are you talking about the economic loss rule for the pure economic loss rule for unintentional? You're first talking. You're thinking
Yeah,
unintentional.
so unintentional is what I'm starting with, but it's a great question because, of course, now actually I just saw this week that the Ninth Circuit certified to the California Supreme Court the question of whether the economic loss rule operates in cases of fraud. That was something that our colleague Jean Browker of blessed memory really cared a lot about and wrote a lot about, and it's a surprise to many of us, including, you know, some judges that I had as guests in class recently, that the economic loss rule might apply to fraud cases, but actually it is increasingly coming into intentional torts. And the idea of economic loss rule, and I think, you know, maybe the way to sort of just give an example for our purposes, the contract context of economic loss rule is something like this. If I negligently fail to deliver wheat on Monday, it is still a failure to deliver wheat on Monday and a contract case all day long. The fact that I put in negligently doesn't change it. And there's this idea that if you're negligently causing pure economic loss between contracting parties, for the most part, we ought to leave that to contract and leave that to areas of contract. In terms of the stranger context, a lot of that is pollution, oil spills. The case that we have in the book is the Southern California gas leak cases. So there's gas leaking in California and there's a 5-mile radius that has to be evacuated, and businesses in that 5-mile radius have to close down. So if I operate a karate studio in that 5-mile area, my business is closed because of this negligence. So I'm saying there's negligence, but it didn't cause me physical harm. I didn't get sick from it. I just can't operate my studio. And so, court, you ought to let me recover. And in that case, the California Supreme Court said, no, we're not going to have a cause of action for negligently caused economic loss. We're not going to say there's a duty. And usually courts in that area say, talk about this in terms of duty. There's no duty to use reasonable care with respect to someone else's pure economic loss. And so
this is a perfect case to discuss in the context of your 12 o'clock workshop as well, because I think this is a good example of a rule that is clear and crude, but crude in the sense not only that it lops off a whole bunch of cases, but the main fear seems to be line drawing. And it seems to me that you could have that there are many defensible lines that do a better job of getting to the right point of justice than this one.
yeah.
So I also wonder, though, I mean, it's also a weird rule because it just forces there to be a lot of pressure on property damage, you know, sort of spurious claims, or, you know, or at least attempts to make claims for actual property damage, right? Like,
Yeah.
describing this as a nuisance or a trespass even, or
Well, two things. First of all, I always say to the students, if you can be in property land as a plaintiff, be in property land. Don't be in economic loss, right? So what's a domain name? We have a case in the book where it's, you know, the case is about someone stealing the domain name sex.com. And Judge Kaczynski for the Ninth Circuit says, that's a property interest and therefore it's protectable. If instead he had said a domain name is not a property interest, but an economic interest, it probably wouldn't have had that kind of protection. And so there are some really funny cases where the question is, you know, did the milking machine that caused less milk production, did it actually injure the cows? And that's why it caused less milk production, in which case it's property harm and recoverable. Or was it just not working properly, in which case it's economic loss and not recoverable? And so that property distinction between property and economic loss is huge. And I think also, if you have economic loss that's ancillary to any physical harm, you're much better off. So there is this question, why do we treat economic losses as this completely separate area, and should we? And so some courts have exceptions, and we put in the book a case with Credit Clearinghouse that caused economic loss, and a court that said, yeah, maybe you can get recovery here because there wouldn't be anyone else recovering for physical injury or property damage, and there wouldn't be any adequate incentives. So you have a few cases like that, and you have some scholars. Kathy Sharkey has written about this and argued that there should be more liability for pure economic loss. And so we do have some of the back and forth in terms of, you know, would we be better off if for the gas leak liability or the oil spill liability, there's not only liability for physical injury, but liability for, if not the full extent of the harms, at least capturing a few ripples.
Very foreseeable.
Yeah.
Okay, one more thought or question, and then I'll cede the interviewer position, I guess. So I also was really excited to at least review these economic harm chapters, because I remembered from law school being baffled by the concept of intentional interference with either contract or prospective advantage, and wondering, like, how is that in any way different from just like a competitive marketplace? Like, how is this not an antitrust violation in a way, if you're preventing firms from trying to compete with each other? Well, so first of all, the more I learned about it, I see that maybe there is some gray area that I hadn't considered, but I, for one, was heartened by the newer cases and the third restatement that have been included in this version, suggesting that you really needed independent legal wrong to which you can attach, if you have intent for that legal wrong to then interfere with either a contract or prospective advantage, that gets you more basically access to damages or to a duty, right? But there needs to be an initial illegal wrong, at least in Utah, and whereas, and I guess there's still a split though, that some courts look for predatory behavior, but it seems to me that predatory is incredibly hard to define. So what do you think of that?
Well, so our co-author Dan Dobbs wrote some articles. Harvey Perlman also wrote some influential articles that tortious interference with contract was too broad and ought to be reined in. And so, now seeing the restatement third that really reins in or is attempting to rein in these torts, and some cases like the Utah Supreme Court's case in John Joe that we have in our book, I know they will be happy to see these cases. It's funny, as I'm teaching some of these cases and really thinking about them again, we go from very broad to much narrower, and I'm starting to feel myself like, should we slip backwards a little bit more? And part of it is, like, if really the only thing that's actionable is the independent legal wrong, why do you need the tort?
Right.
Because we've already got some other tort. So that doesn't make a lot of sense.
Well, you might need the duty.
Yeah. Well, so what happens is, in some of these independent legal wrong cases, the courts are saying, well, you have to identify something that makes this a wrong. And it might be common law action, it might be criminal action, it might be violation of a regulation, it might be some other identifiable norm. And so maybe it's something broader than just something that would already be a tort, because otherwise you think, well, why do we have these cases at all? So I think one of the things that's interesting to see over time is, you know, the flow of, you know, maybe there are excesses on one side, and then as the attempts to narrow it. The other thing is, you know, as with everything, the restatement third is a recommendation from the American Law Institute, and some courts will follow it and some courts won't. And so we see a lot of diversity in what courts are doing. And so it's very hard to, I think that we've done a good job in the book of sort of highlighting some major cases, but also showing some of the variation, because one of the things that's really important, and I think it's great thinking about students and their practice lives, is these are things that are being litigated today are going to be litigated tomorrow. I don't know, Daniel, have you seen some of these cases in action, some of these causes of action?
Yeah, in Arizona, at least, the economic loss rule comes up pretty often, because you do often have, I mean, as a plaintiff, right, your incentive is to allege as much as you can and hope that something sticks. And so it's not unusual to see a breach of contract claim paired with an intentional interference claim, paired with something else that would fall under the ELR. And so it's an issue, I think, that gets litigated quite frequently. And I think, you know, the Arizona Supreme Court is one that I think has, you know, relatively recently, within, I'm guessing, what, the last like 10, 15 years, you know, had a series of cases on the economic loss rule that have really solidified the doctrine. And so now it's one that, you know, is very much at play, I think, in Arizona civil litigation.
I mean, the other doctrines that we added that I think are very much at play in litigation are a lot of these defenses to fraud and, you know, when we're looking at something like fraud or some of the other misrepresentation torts, those questions about could the contract doctrines apply to those? So if we say this is a complete integration and no oral evidence will be taken into account and so on, to what extent do all of those contractual clauses, and we limit damages to $2.75, to what extent do those contractual limitations limit a defense like fraud? And then we also have what I think is probably the most important new issue of our time in the misrepresentation context, which is, do we have comparative apportionment? I mean, the answer used to be there's no comparative apportionment in intentional torts. And when we had no comparative apportionment in intentional torts, there was a hard stop. There's no comparative fault to fraud, to breach of fiduciary duty, etc. But now that we allow it in physical injury torts in some jurisdictions, the question is, well, should we also allow comparative fault as a defense to breach of fiduciary duty, as the case that we have in our book? And a court that says, yes, we allow this in the physical injury context. In the breach of fiduciary duty context says, no, we're not going to allow it, in part because it's alleging fault of a potentially negligent plaintiff, as opposed to comparison of an intentional defendant and a negligent defendant. And I guess the third big addition in terms of the defenses, although part of this is actually just a revision in the book, is, you know, what about economic loss rule as a defense? So something like fraud.
Good. Well, that leaves us 10 minutes.
Tell me something else that you guys, I mean, Daniel, tell me, what's something that you really like that's in the book? What's something that you're looking forward to adding when we have edition 3? As we're already talking about all the things we can include in.
Well, certainly the First Amendment cases around defamation are ones I'm going to be following really closely and to see how that continues to evolve. And we'll read economic loss rules cases more closely, so I could hopefully contribute more to that when the next edition comes around. And in general, I'll just say, just one of the practical things from working on this project that I just thought was really fun and interesting was looking for cases that I think are teachable is a really interesting experience. And I think, what makes a case clear, what makes a case teachable is a case that's clear. And so, it was a really fun experience looking for cases that had interesting facts, looking for cases that stated the doctrine in a way that was both clear but not exceedingly state specific, really general, applied to interesting facts in a way that was cogent and hopefully right, as a means of teaching the doctrine and the law. And that was just a really fun experience. So I think as I kind of encounter cases going forward, it's something I've learned to make a mental note of when I'm like, oh, this is a fun, really teachable case. Just looking at it from the context of the pedagogy.
What about you, Jane? What do you like in the book? What do you?
Well, yeah. So I also I enjoyed much more than I thought I would, just keeping up with cases and reading a whole bunch of cases just to select one. In fact, more generally, I'd say I wasn't sure that I would love working on this book, on this project, but like you kept asking me. And to my surprise, now it wound up being
recorded.
and now I'm excited to teach from it, and I'm on board now. I get why you put so much energy into these projects. And then going forward, as I'm starting to think through competition law and policy, that's sort of where my interest is going, even with like privacy and internet regulation stuff anyways. I'd love to help in the next edition figure out ways to reconcile antitrust principles or even antitrust law for that matter with the sorts of things that these torts are doing. Like, I mean, for example, when one thing is a specific example that has bothered me is that if a company sues another for trade libel or for stating, making what do they call it, a misleading claim in an advertisement or something like that, it can lead to this weird position and sometimes even like an overt settlement that is very anti-competitive. And so a lot of times when we think we're creating something that's going to help consumers, it has this, kind of shadow. And so anyway, I'm excited to work on that.
Oh, that's great. Well, I feel like one of the things that I am focused on more in my older age is highlighting some of the great cases that judges write. And I think, before I thought, well, there are a lot of different interesting cases. And now I think, we have some really talented judges on benches all throughout the country. And the great part about a case book is we don't have to write every word of every page. We can showcase some of the best judges and some of the best thinking. And I think, we're doing a nice job in this book of really finding some of those voices. And that's something I hope to continue. And I just want to say, as Jane's talking about how I kept on her and on Daniel to really, work on this with me. It's been so much fun to work with them. And I think, when I worked on this book with Dan, I always loved working with him. But there's no question that he was teaching me at every chapter, at every stage, And I feel like I would love to, share with them some of the insights that Dan shared with me. Because first of all, it's just a lot of fun reading cases together and interesting cases and talking about the doctrines, and you find that you know it so much better than you would if you were, just reading it. And, as I'm teaching 2 classes now, one that's economic and dignitary torts, and we've covered much more of the dignitary torts, and one that's just more of an economic torts focus. And it's been really nice on both sides to, get that student engagement in terms of, these cases and doctrines. And I guess one other thing that you guys have pushed me to is, our first edition of this book started with a lot of older rules and older principles and sort of showed the evolution. And I remember when I gave my draft of chapter 1 to Jane, and she was like, no, none of this old stuff at the beginning. Like, let's start with what's new. Let's start with what's now. So we traded this sort of old case about a newspaper saying that a man was living with a woman who wasn't his wife to a case where a competitor was calling another dealer Taliban Toyota. And I think that starting with what the law is and starting with the circumstances that we're all living in is more engaging than, let's trace the history of how this got from point A to point B. And so I think that, they're underselling their contribution because even, for every chapter, we had at least 2 of us go through it. And that, careful read and that criticism is so helpful. So I think both Daniel and Jane for, bringing that careful eye to all of the work that I did too.
Thanks.
So, anything else you wanna? Yeah. Oh, we have questions. I'm sorry, we forgot we have questions.
That's why I was like, we have 10 minutes.
Oh, I thought you thought I was like, drag it out. She's like, oh, we have to say 10 more minutes. I'm so sorry. That's why you need co-authors, right? Oh, well, sorry about that.
You can take a question.
Yeah, 10 minutes. How about some questions? We have 10 minutes. No,
Oh,
No, we don't.
okay.
So I don't, this has been a great day for me because I've thought about torts twice today. I've thought about torts in like 10 years or so, but it's really fun. So on the intentional interference with business idea, this may be a facile comparison, but I was thinking about the kind of covenant of good faith and fair dealing in contract law, which I think is kind of a similar idea where, like, why do you need this doctrine? Like, isn't the whole idea that you agree in the contract to what your obligations are? So if the thing is vague, it was meant to be vague and there's no obligation in it, right? But the law instead imposes this extra obligation, even though it's kind of seems inconsistent with the whole premise of the system. And I wonder if it's a similar dynamic that's really just policing, extreme behavior. The thing in the contract context, which I don't know if it's true in torts, is I feel like the way it should work is that it really matters only when you have like a big company that's drafting all the contracts, and then you could see a stronger role for the covenant of good faith and fair dealing because you want that to kind of replace the imbalance in the contracting relationship. And I wonder if the same thing plays out in the tort relationship, where you might see more kind of latitude for that cause of action.
Yeah.
So there's an imbalance.
Well, in fact, enforcing that covenant of faith is really a tort. Is really a tort
Right.
claim. So we have.
Oh, is that in your book? Okay.
Yeah.
Yeah, bad faith insurance breach is in the book.
Yeah. And I think your comment about extreme behavior is correct, because I mean, it seems to me that even the courts that don't go as far as Utah, saying that you have to do something that's already established as illegal, and are still looking for something that's beyond the pale in terms of norms and whatnot, and exploitative. It's just, I always get nervous that once we're using words like exploitative or, manipulative or predatory, we're like admitting that we don't know what we're not defining very clearly what that behavior is.
Yeah. Bill Powers at University of Texas wrote an article called Boundary Wars, and it's great. I really recommend it. And part of it is the boundary of contract and tort, and that's where these torts live all the time. And so trying to balance the norms of tort that are all about reasonable care and the norms of contract that are all about consent and mutual agreement is constantly at issue in torts throughout the book.
All right. Okay, go ahead. One.
Thank you.
One
Sure.
more. Sure.
So my question really pertains to the unveiling of like anonymous posters on the internet. And I'm in the class and I grappled with this issue of like, yes, that's always anonymous pamphlets and whatnot have always been in existence, but I feel like in this day and age where everybody can share their opinions so easily, I wanted to kind of impose more responsibility on people who are sharing their opinions. And if it is defamatory, that perhaps that lower demand of just a good faith basis to have their identity unveiled should be what courts adopt. But then there's also the worry of plaintiffs abusing that. And I guess the question could be more for Daniel, but I mean, is that abused? I mean, is this like a trend that is it just kind of, oh, we're worried about it being abused, so we're going to clamp down on it now? Or are there actual occasions where it kind of calls for that higher standard before an unveiling happens?
And I'll defer to Jane and Ellie since they're the experts on the unmasking.
Unmasking. Yeah, well, so I don't think we included the Laskula-Cohen case. I think in the end it was on the chopping block. But one of my favorite cases that shows that it can be, that process can be abused, was a case where someone, I think it involved two fashion models. And so one of them was like constantly making fun of the other. And so then the other sued for defamation in order to unmask this anonymous blogger. And it was pretty obvious all along that no one was actually looking at the blog except for Laskula-Cohen herself, who was like enraged. And she just wanted to use the process to kind of harass the anonymous blogger. And so I don't know, I'm of sort of two minds. Even in that case, I can see how, well, it is really enraging to have someone who's obsessively posting really negative content about you that may be seen at least by some people. And actually more generally too, the internet, I think I would argue just kind of normatively that the internet does make it a bit too easy to engage anonymously. I mean, by design, by design, the internet protocols are pretty anonymous, and other than the ISP contract, it's, or a website taking on the burden of forcing people to identify themselves, the default is anonymous, and I don't think that's a good default. So I'm kind of sympathetic to what you're saying, but courts see these First Amendment cases that I actually don't even think are very well reasoned, frankly, but about, compelled disclosure of a person's name and applied literally, these, it makes sense that they have a lot of process before you can do this.
Well, it's interesting because my favorite case, which we also didn't put in the Glassdoor case on the unmasking, but there are a lot of great cases, and the one we have in the book is really good because it's better than the two that we both really like. But it highlights how much we trust online information. Like, you see information about a company, people post all these negative things on Glassdoor, and it might not even be an employee, and yet it's hard for Glassdoor, it's hard for the company to get from Glassdoor the information about, are these people writing the negative reviews, even, you know, people who legitimately worked at the company. And so I'm sympathetic also to that problem. And I think it's still really the infancy of the development of these tests, and probably, you know, 10 years from now, we'll all say, oh, there's this standard test where it will all be worked out. But right now, there's sort of a range of tests that courts use in terms of how much do we want to protect those posters and how much do we care about making sure that information on the internet is true. And I think in the early days of the internet, the idea was just get more information out there. And now that we have so much information out there, there's a little more attempt to control, you know, is that content accurate? Is it responsible?
Luckily, though, the end user websites have an interest. So the market is responding to some extent, because Glassdoor and Yelp, they don't want to have their brand degraded when people realize that the reviews are, you know, a lot of them are false or whatnot. So that helps, but.
So there's always the market as a competitor to any kind of regulation, whether through tort law or something else.
Yeah.
Thank you.
Yeah.
Thank you so
All
much.
right, well, thank you. This has been just fascinating. Thank you so much for joining us. Thank you, Daniel, as well.
Yeah, Daniel, welcome back.
Thank you for having us.
It's been a pleasure.
Did you include the Gawker case?
Are we on?